Luke. Well, developing right now, that injunction temporarily blocking Florida's 15-week abortion ban went into effect this morning.
But the state of Florida has already filed an appeal. Local 10's Christina Vasquez joins us with what it all means. Christina.
And we have an update since then. So essentially, the second the state appealed, what that did is kick in what's called an automatic stay. Essentially what that meant is that temporary statewide injunction that went into effect this morning only effect for about 39 minutes before it was put on hold. But what I'm reading right now, my phone as I'm joining you live, is at 2:48 p.m. The attorneys representing the plaintiffs in this case, they just filed a motion into court asking a judge to now lift that automatic stay so that temporary injunction can go back in effect. What you need to know is that we are in the infancy of what's expected to be a long legal tussle over state constitutional rights to abortion access here in Florida. The block on Florida's new 15-week abortion ban was in effect for less than an hour. That's because just over 30 minutes after the judge filed his written order granting a temporary statewide injunction, the state filed this appeal, placing the injunction on hold.
Now, we do plan to very quickly today file a motion for him to vacate that stay.
That's ACLU Legal Director Daniel Tilley. They plan to ask the judge to lift the hold. They're representing the plaintiffs in this case, providers like Planned Parenthood, who argued Florida's new abortion law that took effect Friday, HB 5, banning abortions after 15 weeks, previously was 24, would unlawfully intrude upon the fundamental privacy rights of Florida women. And Leon County Circuit Judge John Cooper agreed. And not just because Florida's state constitution has this privacy clause, but based on how the Florida State Supreme Court, he says, has historically determined that it extends to a woman's decision of whether or not to continue her pregnancy. He also writes that the recent Supreme Court ruling ending 50 years of federal abortion rights doesn't affect his analysis because, you got it, this privacy clause, unique to Florida's state constitution and broader in scope, he said, than any privacy right under the U.S. Constitution. Here's constitutional scholar Carolina Mala Corbin.
The major difference between the U.S. Constitution and the Florida Constitution is the U.S. Constitution does not have an explicit right to privacy within it. The government cannot interfere with intensely personal decisions.
HB 5 is not a significant restriction, and the governor's office said it will ask the Florida Supreme Court to reverse its existing precedent regarding Florida's right to privacy, essentially to overturn its own decades-long determination that this privacy clause grants state constitutional rights to abortion access.
If the Florida right to privacy was reinterpreted to take out the right to abortion care, that would be a radical and horrific change in Florida constitutional law.
ACLU's legal director, you heard him in this piece explain that they were rapidly working on filing a motion with the court asking the judge to lift that hold on his own granted statewide temporary injunction. That motion was just filed 2:48 p.m. So we'll have to see if the judge plans on ruling on that by end of day. So here we are a bit in this legal limbo as it stands right now. Florida's new 15-week abortion ban is in effect. That temporary statewide injunction is on hold, but this is definitely a stay tuned as we work through into the 5 o'clock hour when courts close. We'll see. Reporting live for you, I'm Christina Vasquez, Local 10 News.